Welcome to Your Condo Connection, the CCI video series designed to assist condominium purchasers, owners, and boards. We hope that you'll follow our series and listen to the experiences shared by our multitude of expert guests. In this session, we're going to spend a few minutes looking at a very serious topic, the issue of protecting the revenue for a corporation through the issuance and placement of liens. And to help us through that, we have Maria Durdan. Maria, thank you for joining us today. Now, Maria, you're a lawyer specializing in condominium law with Simpson Wagle Law, and you are also on the board of directors for CCI Golden Horseshoe.
That's correct.
All right. I'm glad we have a lawyer here today because this is a very serious subject. Now, Maria, condominiums register liens when owners fall in arrears. And on the surface, for somebody new, that might seem a little drastic. Can you give us some insight to the lien process?
So under the Condominium Act, corporations have an automatic right to register a lien against a unit in the event the owner is in arrears of their common element fees. Keeping in mind that the common element fees are not only comprised of the monthly common element amount, but also any additions which are permitted pursuant to the condominium corporate documents, such as insurance deductibles. So in the event an owner is in arrears of the common element fees, the corporation would attend to sending a Notice 14 and outlining the amount of arrears and any interest owing, as well as any reasonable legal fees which have been incurred by the corporation in trying to get those arrears paid by the unit owner. From that time, 10 days must pass, and then at that point, the corporation can attend to registering the lien against title. An owner shouldn't take this registration personally. What the corporation is simply doing is making sure that they're protecting their single source of income, being the common element fees, which they need in order to perform those items that are listed in the budget of the corporation.
Wow, okay. So even though people may fall into arrears and jeopardize the cash flow, there are some rights built in with notices that have to be given to them and that sort of thing. That's very helpful to know. But on the other hand, if a person is liened and still refuses to pay, what happens then?
So in the event an owner fails to pay those arrears in total, the corporation is in the place to actually commence power of sale proceedings. And technically, the corporation can commence these proceedings 15 days after the Form 14 is sent to the unit owner. But we generally recommend up to 90 days, being 3 months, in order to give the unit owner ample time to actually give those arrears or pay those arrears and bring them up to date. In the event the owner doesn't pay, let's say after 90 days, the corporation would then issue a notice of sale under lien and would again advise the owner how much is in arrears, how much interest, principal, a description of the property. And then once that is sent, they have 45 days to pay. During that 45-day period, the corporation cannot take any further steps at that time. But again, if the owner still fails to pay after 10 days, 90 days, 45 days notice, the corporation would attend to issuing a statement of claim. Then the unit owner would have a right to issue a statement of defense. And if the corporation is successful, they would get judgment and ask for the unit to be vacated or attend to it. And then the proceeds would be distributed accordingly.
Wow. So, I mean, ultimately, the heavy hammer in this whole thing is that somebody could take your home away from you.
It is, but at the same time, a very small amount of units actually get sold under the power of sale proceeding. The majority of the lien matters settle either during that 90 or 45-day period where the unit owner pays or the mortgage company pays on behalf of the unit owner and then adds that amount to their mortgage amount.
Well, that makes sense. A mortgagee, a bank wouldn't want to let their investment go for just a few months of fees.
Yes, yeah.
Oh, that makes a lot of sense then. So it sounds to me that while this whole process is protecting the many in terms of the revenue they need, there are lots of inherent rights protecting the individual who even falls into that position.
Yes.
Okay. Well, Maria, this is a really serious subject. It certainly is going to affect somebody's credit rating, that sort of thing. So I'm going to put you on the spot. If I could leave you with any final words, what would you want to leave our viewers with?
I would say that the power of a corporation to register and to enforce liens is extraordinary and must be taken seriously. At the same time, the corporation has an obligation to ensure that single source of income, being common element expenses, are being collected because they're used to undertake the obligations of the corporation, to pay insurance, to pay utilities. So if unit owners are late in paying their common element fees or just refuse to pay them altogether, the income of the corporation is depleted, which will have a negative impact on the financial status of the corporation. So if I were to leave you with one comment, it would be that boards of directors who have a duty to protect the property and the assets of the corporation have a duty to enforce those lien rights for the corporation's benefit, but also for unit owners to protect their interest in the property.
Wow. Okay. Very good. So we're protecting everybody. There are rights for everybody on both sides of this equation. And as you said earlier, and I really like that, it's not personal.
Right.
All right. Thank you so much for coming and sharing that.
You're welcome.
Hopefully that helped to clear up this very serious legal issue about liens and falling into arrears and what can happen for you. Until next time, I'm Murray Johnson, and this has been your Condo Connection.